Good afternoon, everybody. Everyone has entered the webinar as a mute attendee, but Zoom webinars features include a Q&A tab where you can ask any questions during the webinar. We'll collect them all and answer them either live or afterward by email. Also, you can click and drag the boundaries between the windows to adjust the size of the slides or the presenters. And now, after a brief introduction, we'll proceed with today's webinar. As always, co-sponsored by the University of Florida Levin College of Law Institute for Dispute Resolution. And here are our presenters for today. After starting his career as an assistant state attorney, Greg Donoghue limited his practice to personal injury and insurance disputes. He has tried more than 150 civil cases to verdict. Greg is recognized as a civil trial specialist by the Florida Bar and the National Board of Trial Advocacy. Less than 2% of the state's civil trial lawyers are board certified. He is also recognized by super lawyers as being among the top 5% of attorneys in Florida, as determined by independent research and peer evaluations. Greg has 35 years of personal injury and insurance litigation experience. And April Walker, licensed by the Florida Bar in 1997, her litigation practice focuses included business and commercial, loan servicing, and consumer financial services. She has been recognized by peers as a Florida legal elite in commercial litigation. April has been mediating with Upchurch, Watson, White & Max since 2018. She has advanced mediation and negotiation training from Harvard Law School. She is a member of the National Academy of Distinguished Neutrals and a fellow of the American College of Civil Trial Mediators. And now here's April with our topic.
Well, thank you, Kathy, and hello, Greg. We've already kind of chatted as folks were entering the webinar. Happy to be with you today in today's program, Keys to Unlocking Your Client's Best Result in Mediating Tort Cases. And before we go forward, Greg, let's talk briefly about the breadth of your experience on the litigation side. Did I hear you have over 25 years of personal injury and insurance defense?
I do. I spent about 12 years as a partner in a defense firm that was out of Orlando, but I tried cases all up and down the coast, mainly from mostly, from West Palm up to Melbourne, where I am today, here in Melbourne, Orlando. And so I have tried a lot of defense cases in that period of time, some medical malpractice, mostly auto insurance disputes, that type of things. For about 12 years, I did that. And then the remainder of my career, I opened my own personal injury firm where I was the managing partner. We were a smaller firm. I think the most I ever had were 5 lawyers at one time. But we rocked along here in Melbourne, doing our thing for about like 27 years. Okay. So I tried a bunch of cases on both sides of the fence, and I can tell you I was never one to take a jury verdict on either side of the fence for granted. So that's why mediation is super important, and being prepared for mediation and having a foundational formulated approach really is going to help you going forward, whether you're mediating cases or litigating cases, which hopefully can be avoided. And that's why we're here today.
Fantastic. Well, it bears comment then that as we begin today's program, and obviously now you're mediating exclusively,
yes,
but you have a breadth of experience from each seat at the table on the plaintiffs, defendants, as well as now as the professional neutral. So I think we can go ahead and jump in.
Sure. That's great, April. Whenever you're ready.
Okay, so the first step in what you've called a systematic approach for preparing for tort mediations is crunching the numbers. Let's talk about that. I'm going to let you talk first on why that's the first step.
Sure. Well, if we
next slide.
Yeah, if we can go to the next slide. Really, I think you would agree with me on this, April. In personal injury cases, I hate to say it this way, but really it is the numbers, and when you get down to it, the dollars that drive things. In most personal injury cases, aside from the occasional, the defense wanting a non-disclosure agreement, there's not a lot of non-monetary terms. So, you don't want to be crass about it and saying it's all about money, but because it isn't, it's about injuries and compensation and justice for people. But what we present at trial and at mediation, a lot of it are numbers or figures. So what I see, both in my own practice on both sides of the aisle, so to speak, and with successful attorneys at mediation, is that they know their numbers. They know their medical numbers. They know their intangible numbers. And I don't want to get in a huge discussion of intangible damages, but if you come into intangible damages at a mediation when you don't have a lot of medical expenses, you have to explain why that is. Because, for instance, if you have a client that's, I hate to talk about horrible things, but personal injury, kind of tragedy is our business. But say you have a client driving along, somebody hits them, their arm gets cut off. They might not have a ton of medical expenses, but they're going to have huge non-economic damages. So, there's not always a direct correlation between the medical damages and the loss of wages and the injuries, but in most cases there really is. So there is a correlation, but not every case. So that's why if you come into mediation with a client that does not have a lot of expenses, but has big intangible damages, then you really have to have a foundation for presenting that. Some of it, obviously, is the presentation of the client, what their injuries are, what their injuries are on paper, the things that you can't see, the surgeries they've had. Some of those, you may need graphics even at mediation to show hardware and that type of thing. So when you're looking at the numbers, don't ignore the intangibles, but just have a foundation for them. As far as medical expenses for treatment for cases that arose before March of 2023, tort reform. And by the way, I think that really has changed the face of things. So if I'm not making that clear, attorneys know that more than mediators, but it affects us as well, April. But I would say this, with past medical expenses, I think the 5th DCA has now kind of laid down the law on that the cases pre-tort reform, that the former system of dealing with medical expenses and what you could board has not changed. In other words, it's not retroactive. But going forward, I would tell attorneys that, in my view as a mediator, it would be a really, really good idea to start figuring out how you are going to present medicals at mediation and by way of assigning them to the trial too, but how you're going to present those, because for instance, you can go to your provider and say, hey, I need all the codes for this, because now guess what, you're going to be compensated not at what you charge in your letter of protection, but 120% of Medicare B. So that's a big change, and that's going to affect a lot of things. And so attorneys aren't allowed to testify. So when you better have those codes ready, and you better have some medical support for that. So what I'm saying here is, I don't think that this is all going to be a disaster. I think it's just changed things, and it may in the long term benefit things. So just know your numbers, and especially for cases going forward, know your numbers. And as part of that, April, I would say your liens, know the formulated liens, like for Medicare and Medicaid and work comp, where you have the Manfredo formula. Be working on those and know those, and know what those lien amounts are coming in the trial, because my suggestion and what I did on the plaintiff side was, I would present before, hopefully weeks before, a kind of like a spreadsheet of what the numbers are, what the liens are, what the medical expenses are, what the futures are, and help, if you're on the plaintiff side, help the adjusters help you. We hear about mediation being a collaborative thing at times, and I think to a large extent that is true. I mean, still we have an adversarial system, but if you go into it as not seeing opposing counsel and insurance adjusters as the enemy, but that you are working together to solve a problem, I think that works very well. It's not like you have to reveal every little nuance of your trial strategy, but you can certainly help somebody go for authority and roundtable your case in light of the information that you're presenting. Did you have something to add on that regard, April?
Well, first off, I think it's interesting to note that I agree first when it comes to the tort mediation, start with the numbers. It does matter. And you can best believe it will pay dividends when you get to the conference, because you'll find that's exactly what the other room is focused on and what the adjuster's coming to talk about. Also, before we move forward and talk about the other items on your slide, I think it's interesting that some lawyers might focus in on key evidence first and or their key documents, their hot documents in preparation for their opening remarks. But again, don't leave the numbers for the end. Focus on those first. And as we continue through your suggested approach, Greg, it'll be clear why it's important to do this as a first step. It is a collaborative process. So if you've done this well before you get to the mediation, it does help the entire process.
Yeah, good point, April. And I would say, I kind of touched on this already, but I would say post-tort reform, future medicals are going to be, I don't want to say a flashpoint, but they are going to be a focus of attention. I think the defense is going to go do deep dives on that, and rightfully so, of course. So the plaintiff's attorneys need to be prepared to know what you are going to be able to present, and some of that may, frankly, just at trial anyway. It's certainly going to take expert witnesses, but if you have a handle on the codes and what the doctors have presented for future medicals, and if you know the reimbursement rates, that's going to be a big help at mediation. The tough cases, I don't really want to make this about tort reform, but I'm just telling people what to be ready for. But the cases in which your client has submitted bills to insurance and they have been paid by insurance, the reimbursement rates, so you're great going into mediation or trial with those. The future meds, when those numbers have been compensated, or when those bills have been compensated by insurance in the past, going forward, trying to figure out what the insurance company would do and what they would pay and at what rate, it's going to be a challenge. I mean, I got caught up in my verbiage a little bit there because I'm trying to think, how is anybody going to do that?
Right.
So whatever you're going to do, and that's up to every litigator and every firm to figure that out. I would say start now. Start figuring out now what you're going to do for when these cases come up, because it's really going to make a huge difference for your clients.
Agreed. You've also got calculating trial costs, or I think of it as the cost of trial. So if there isn't a settlement, what other work from the attorney perspective, the team perspective, what that looks like, and expected recovery. Can we talk about expected recovery, Greg? Because here I think, we start really kind of nailing the difference between a verdict versus what plaintiff takes home.
Right. The expected recovery, I think maybe we'll cover a little bit more in the next slide, but I would say, because so much of what we're doing, it kind of bleeds over into the next topic. But as far as the costs that you mentioned, I do think it is good to, within your firm, decide really what you think, or determine what your costs are going to be if you take that case forward to trial. By that time, you generally know who your experts are, what they charge, what it costs to have a court reporter in the room, and based on past trials that you've had, what percentage of your costs are usually recoverable. Sometimes that cost can be recoverable, but the judge will only give you 66% of it or 75% of it. So I think it's a pretty rare case where you get 100% of your costs, even the recoverable costs, and some are non-recoverable. The reason that's important is because that figure at mediation can really help you to determine whether or not you are better going forward and trying that case, or if you're going to have $30,000 in unrecovered costs, whether you might be better off settling that case at mediation. And my point of view, both as a litigator and as a mediator, is that 95% of cases can and should be settled at mediation.
Agreed.
And
And then
then
go ahead. I was going to say, last you make reference to past and or future wages, which you touched upon in terms of knowing the components of the damages that you're needing to focus on for the next step. But specifically as to wages, Greg, what was your thought process there?
Wages, the claims that I see, if somebody, like here in Brevard County, for instance, we have a lot of engineers, they work at, Harris L3, Grumman, SpaceX. Their lost wages, if they're out of work or they've taken family medical leave, those are pretty easy to determine. So obviously know those, get with the client, get them to get the information from their employer, because I see as a mediator that sometimes wages are not sometimes they're left on the table, really. But the roughest cases for wages are when somebody is self-employed. And just have to be completely honest with there, as somebody who's dealt with a lot of these cases. A lot of times the people that are self-employed, if they're a house painter or a mechanic on the side or whatever, they don't file tax returns a lot of the time, maybe not all the time, but a lot. But they can still present the claim. But if you're going to say that you have lost wages, you got to have some type of proof. And the way you do that is, if obviously to be successful at mediation, the way you do it is to give the adjuster something to work with. What can you compare the tax returns? Can you show that this person had to hire an employee or an independent contractor to help them? So the wage is part of your claim, and it's just good to be straightforward of it or with it. But a lot of it's up to the client, and you really have to keep after them to get you that information. So from day one, if they come in and say, oh, gee, I lost jobs, I can't do this, I can't do it as well. I mean, you can always come into trial. A person can always testify at trial or present at mediation that they feel that they've lost wages, but it's probably going to flop unless you have some evidence to show it. So if you've got it, put a little work into it, show it at the mediation.
And you certainly don't want to lose the opportunity to settle the case because you don't have the information to provide the other room. Okay, let's go forward. So the pre-mediation client meeting. So once counsel has crunched the numbers and done the work of employing or asking their paralegal and whoever in the office to help them nail down lien information, et cetera, now you're ready to move forward to client prep. Let's talk about it. Next slide.
Would you like for me to cover this, April? Or
if I can say this,
sure, you go ahead.
Let me start off here, because I sincerely hope every lawyer is having a pre-mediation client meeting. I know that clients can be difficult to nail down for these meetings, but you can never underscore how important this meeting is to the success of your mediation. And I'll say it's not a guarantee that a mediation will end with a settlement agreement, but I have to say it's a critical first part as it relates to client expectations, and for you as their lawyer having a very clear understanding of what are they wanting out of a settlement. And then to the extent you go through the things that Greg is going to talk about next, how much has your client received the information and digested it? And I'll come back after you talk.
Well, we have a lot to cover with this one.
Yeah.
And maybe this was the most important thing in the presentation, because it's very foundational. For me, as a mediator, and from what I see at mediations, the timing of the pre-mediation meeting should be, probably at least 2 weeks before the mediation. I mean, sometimes that's not always possible, but the big thing about a pre-mediation meeting with the client is you never want to have your client surprised by something at mediation. And trust me, when you're defense counsel, you can see it in their eyes when, you know, they eyes get wide and they look over at their attorney, and you know they've never heard that before. So you don't want that. You want the client to be fully prepared, and this takes some time. You know, it can take a couple of hours to sit and meet with a client, but it pays huge dividends at mediation and will go a long way to get your case settled. So first of all, have the meeting. Second of all, I think this is a meeting that should take place with the client in your office or whatever, a personal meeting rather than by Zoom. Do you agree with that, April?
I absolutely think it needs to be a face-to-face. At the very least, a Zoom, certainly not a phone call. But the best situation would be have them come on into the office.
Absolutely. I think that really is a huge help. But client expectations, this meeting is good for bringing to the light what a client may be looking for and trying to determine and help them determine whether or not they are taking a reasonable basis to their own evaluation of the case. So I think the best way that I see attorneys do it is when you have this meeting with the client, you know, as the attorney, you know, you're the leader of this thing. The client's at the helm as far as what they want to accept to settle, but you know, you're the professional, you're the one that's put the case together, you're the one with the experience. So bring the client in and you discuss with them everything that you think is going to be presented, the strengths of their case, the weaknesses of their case. I'm not suggesting, and I would never suggest, and as a trial attorney myself, I would have never done it. I never wanted to bring a client in and try to beat them into settling or intimidate them. What I do want them to do is be informed. And when you inform a client in a reasonable, rational manner, generally they're going to get it. And they are going to understand that their evaluation of the case may be different than yours. Sometimes your evaluation is higher than theirs as the plaintiff attorney. It just depends upon the personality of that person, their risk tolerance, where they're coming at the whole thing from. So you go over the strengths and weaknesses, and one of the big ones after tort reform is comparative negligence. And as we all know by now, we went from pure comparative negligence to modified. So you never want a client at a mediation with disputed liability not understanding that if they're 51% liable, they're going to get a big zip. And you know, that's really important. You don't want to have a case go to trial, your client doesn't get anything, and then they're like, hey, you never told me this. So, you know, if there are monsters to present, you present them at this point in time, at this meeting, so the client isn't surprised. So did you have something to add on that?
Yeah, I'm glad thank you. So even when it comes to the liability issue, and I'm glad you raised this one with the comp negligence change, there are situations where, and I recently had this happen in a mediation, where plaintiff comes into mediation and believes that there's no dispute as to liability and finds out in the conference that frankly, they have not seen some evidence. They've not seen something has not been turned over yet in discovery. And all of a sudden it's like, wait a second, they were prepared to talk about causation and damages, thinking liability wasn't an issue. So I would say, even in a situation where it appears liability is not disputed, it pays to go ahead and alert the client about this law, just in case something comes up. It's not the first time they're hearing it.
Yeah, excellent point. And that is so true, because it you know, it can be like a grenade in a case. So you want to be super careful. Another thing to speak about is with the client is the proposals of settlement. We have a slide for proposals, what we feel is the effective use of them, but absolutely 100% have your client on the plaintiff side and on the defense side now. The bad faith really isn't what it used to be. And I would just add at this point as an aside that if your client has exposure on and they're the defendant in the case, I mean, you have a duty to talk with them as their attorney about, you know, what their potential exposure is, because you know, it used to be, well, if there's an excess verdict, there'll probably be a bad faith case, but now there are situations where a defendant who has assets could be collectible. So they need to know about proposals of settlement too. But especially with the plaintiff, they need to, in terms of when you're serving them, but also at mediation, let them know those numbers that are out there, how proposals work, how likely it is that a proposal, because it's not an outright guess, but it is something that we have to approximate on. So, this meeting is all about risk tolerance and letting the clients know what they're in for. But if there's a proposal of settlement that the defense has had out there for a long time, and your case has changed, you found out that the client really, wasn't as forthright at the mediation, rather intentionally, or, they just misspoke or whatnot, but for whatever reason, if that expired proposal of settlement is a threat, that really can come into to play out of mediation where you're determining if you want to settle. And same goes for the defense. Do you mind if I move on to the next point, April? Or did you?
No, not at all.
Okay. The attorneys, oh, I'm sorry, not the next slide, the next point, but I'll blaze through this pretty quick. But what I see a lot of is that on attorneys' fees and costs, this is where you tell your client and remind them what the contract says. And trust me, in my firm, we went over that contract a lot when we first met with the clients. And I see it in so many cases, in so many mediations, where the client is like, oh, I thought the fee was 33 1/3, or I thought the fee was 40%, and that included the cost, and that not realizing the plaintiff's put, advanced $25,000 worth of cost. So, that is something that if there is any haze in the air, clear it then and let them know what
Yes.
that contract says. Because when you're doing it at mediation, it kind of, it has you retreating from the get-go, and they're trying to guilt you about your fees. So, they are what they are. That's what the contract says, and clear the air about it. But and then one of the biggest things about these meetings, you've told the client everything you have to say, and then you ask them, what do you have to add? What are your thoughts? Do you think we have looked at something differently than you do? You never walk into a pre-client meeting and say, hey, what do you want? That because they're going to say $10 million, so you really never walk in and say, gee, what are you looking for? You have to guide them with your professional experience as to where you think the proper evaluation and settlement figures are in that case. So I think it's a dangerous thing to ever ask a client exactly what they want until you have discussed where you're coming from. But then get into any disagreements, and then in this way you have a few weeks to try to smooth it over. You can get second opinions, you can show them verdict reporters, you can do a lot of stuff. So
before we move on, let me add to
sure.
that, because I would say as counsel, this meeting is again crucial. It's important for you to be intentional about unearthing anything your client's feeling about what you're saying, because you don't want, and as we move forward, you'll see that if you do this well, as you proceed to mediation, now your client will be hearing something they've already heard at least once, maybe twice. And oftentimes repetition helps a layperson or a client who's not a lawyer say, wait a second, this is important. Now I understand why my attorney talked to me about this and kept bringing this up. But what I'm saying is, don't go into the meeting quickly to tell your client, this is what we're going to do, and not take the time to hear from your client. Because
sure.
If you find we have it here as disagreement, that's an opportunity for you to utilize us in advance, right? So know in advance so you can utilize the process and
Right.
the mediator.
I'm not suggesting you go in and dictate. I'm suggesting that, you tell them.
Oh, absolutely.
Yeah. But one thing I did overlook just real quick, and I think this is something that helps attorneys get cases settled, is you present at the meeting ranges of settlement that the client should consider. And the way I see a lot of attorneys handle that is there is a figure below which, unless there's something dramatic at mediation, that they would advise the client not to settle. Whether the client wants to settle, whether they want to take every offer, we all know it's up to them. But there are offers below which you would say no, if that's the way the defense evaluates the case, we understand their position. But we're not going to take that. Then you get into the low range, or you're like, well, if you want, depending upon the risk. And then the mid range. The mid range is the sweet spot where I think you may agree on this, April, where probably every or 90% of cases settle. And that's really when you have this systematic approach, that's really what you want to do. You want to get yourself in that spot. You want, of course, from the plaintiff's end to get it as high as you can, on the defense end as low as you can. But in that mid range is where things work. And that's where, you have an adversarial system. If you get to, you're getting everything you want in the case and the client's balking about it, you better have a real talk about, you're probably going to try this case and not come out as well. Because they're giving you what your case is worth on your best day. So
Yeah.
All right. With that, I think we can move on.
Yes, we can.
Thanks, April.
So offers, the proposals for settlement, offers of judgment, kind of made reference to these already, but go ahead. I know you've got some thoughts in terms of how to strategically use those.
I do. What I would say about the proposals of settlement is this: what we saw in the past, and mainly for bad faith purposes. I hate to keep mentioning bad faith, but it loomed large in personal injury for a long time. But you'd see a proposal served by the plaintiff at the policy limits, just to be on the safe side, and then the defense would respond with one for $1,000 to throw a salvo over the bow of the plaintiff's ship, saying, hey, we don't evaluate it like that. And a lot of times what I have seen at mediations is nothing else is ever filed. Or I keep saying filed, they're not filed, they're served.
Served.
And I think everybody's missing opportunities there. I really do. We lawyers and we human beings, sometimes we want to hold back information thinking there's going to be a better time to use it. And sometimes the longer you wait, the less value that information has, really, from what I've seen. But what I would say is, when you're deep into the case and you feel that you have the value of the case pretty much nailed down, is a time to put out a good proposal of settlement. If it's below the policy limits, then do somewhat above where you think the case is and give yourself a little room. And on the defense, say, hey, this case is worth more than $1,000. Let's put XYZ on it. Because in those mediations, I think everybody comes in with a better feeling about the other side. Do you agree with that, April?
Absolutely. Yeah. And if time has, like you said, if proposals for settlement were served early and work has been put in the case before mediation, at the very least, if you still have time to serve one, you can serve another one, and or at least be communicating with the lawyer on the other side about where to start off at the mediation. And if you do it in advance, Greg, then we don't lose time at the actual conference doing that, because inevitably you wind up having a tug, and or the first demand is limits, and then as mediator we're walking over to the defense room. It's like, wait a second, what about all the things we've unearthed in the discovery? There's no consideration of comp negligence here, blah blah blah.
Yes, well said. I'm glad, your experience came to play on that one, because I think that is very common, and it can save everybody some time at mediation. And when the client, when you are in that position on the plaintiff's end, the proposal of settlement can really loom large. I've dealt with so many cases and so many mediations where if they don't settle that proposal of settlement, when it came down to the crunch time, it was pretty meaningful. And I've tried many a case on the defense side and on the plaintiff side where well-placed strategic proposals of settlement really carried the day. So they're a tool out there, whether or not they're fair to one side or the other, or more, whatever. I'm not a police officer here to straighten everything out. All I can tell you, or a legislator, all I can tell you is that proposals are out there, and if they are, use both sides, use them to your advantage. But this guy kind of goes back to the collaborative thing, and I feel like we just discussed it. If you come in there, both sides are showing good faith with their offers, that you're probably going to settle that case.
Now, have we adequately discussed communicating with opposing counsel before the conference?
I'm sorry.
No, that's fine. Let's go. Let's make sure we cover that. It's in the middle.
Yeah. I'm sorry, I skipped over that. Yeah, that is super important. And I apologize for missing that, because I think for some reason, a lot of times attorneys don't communicate with each other verbally about this. So thank you so much. What I would say is this: first off, when you serve a proposal, if you are serving a proposal that you believe is somewhere in that range, even if it's the high range, you do want to call opposing counsel and say, look, we're trying to be straight up about this. We're not going to have a ton of room to move. So you might want to tell your adjuster that, we kind of really mean this one, and this may be a case we want to try. Same thing goes for the defense. If the defense attorney, if the case has been evaluated at something that the plaintiff may not be happy with, you just have to tell them, this is how we evaluate it. This is where we see this going. We think there's some things you may be overlooking, but we're going to serve this proposal if you haven't already gotten it. And, don't expect us to go up dramatically, because this is a pretty solid offer here. And I think when that has been communicated, it's taken seriously, and everybody has a lot more respect for each other. Would you agree?
Well, yeah, because what you're doing is you're at that stage of the case before mediation, now revisiting something that may have been served early, and or opening the door to have a conversation, again, that allows your opposing counsel to have a conversation with his client. So this actually makes me think about the timing bullet on your pre-mediation client meeting, because if you think about it, you also want to provide opposing counsel with some time to talk to their client about your offer. So you may even, and again, I understand lawyers are busy and you've got workloads, but when you have agreed to a mediation date and a notice of mediation is being served, you can quickly reach out and say, hey, how early, in terms of your client relationship, how early do you need to receive, an updated number from me? And they may say, I can't get anything done from my client if you wait 2 weeks in advance. I need something earlier than that. I mean, just pick up the phone and try to have that rapport to find that out.
Great point. Great point. And just one other thing before we move on this. If, let's say, you're on the defense side and you have served what you believe, or your adjuster has given you authority to, serve a proposal that they feel is around the value of the case, and it's a little bit higher than, what you may have expected or whatnot. But if something changes, say, that on the defense side, you find out that the plaintiff actually applied for Medicare 5 times and Social Security disability, and that didn't come up at deposition, and they just said, I never have done that, I've never had another accident, I've never had another injury, just anything that really makes that go south, the case goes south for the plaintiff. When you're the defense and you are not going to come in and negotiate upward from where you were, you have to communicate that, or the case is going to impasse. Same with the plaintiff. If your client has had surgery 2 weeks before the mediation, call the attorney on the opposing counsel and tell them, look, they just had a surgery. We've got the bills together here, or it's XYZ number, and that gives everybody some breathing room to get something done. So if you're going to come into a mediation and not go up on the defense side and actually retreat from your offer, and if you're on the plaintiff and you come in hugely higher from where you were, then you want to discuss that, and you want to have a solid basis for doing that, or you're going to impasse.
Yeah, I agree. Okay, let's move forward. Okay, so the prep has been done, and now we're at the mediation, because we're now at the joint session where counsel have the opportunity to make their opening remarks. And I know in certain jurisdictions, even certain areas of our state, Greg, there are lawyers and mediators who frankly go straight to caucus. There may not always be an opening session. I like them. They're an opportunity. I find lawyers like an opportunity to speak directly to the client on the other side. So let's talk about how to now take the work you've put in before the mediation day and convey it in the first time you speak at the mediation.
Sure. I have been in many mediations where opening statement is waived. And I think the reason is because sometimes you get in there and you're like, we all know this case, everybody knows the case, but really some of the players may not. But it's also how you present yourself and how you present the information, which I think can have kind of a subconscious effect on everybody. If you just jump right in, which in some cases may be appropriate, and I get why people do it. But I think an opening statement is good. I don't think they need to be very long, but the first thing I would say about an opening statement is make sure everybody has the numbers. If I would have mine there, every mediation in printed form. I would have a sheet that everybody got, hopefully even in the mediator, send, please send this to us too. But everybody would have our numbers. And I can't tell you how much that helped. So all the preparation we've talked about, you come here, you make an opening statement, and what you really want to make positive of is that you're as up to date as possible on those medical bills, because you don't want to find out either during the mediation when when your staff is calling or something, trying to figure out what medical bills are, that things are really a lot different than you thought. And I have seen that happen. So really, I get people are busy. I mean, I have truly been there myself. But the formulaic approach to this and starting to get these numbers together from day one and putting them in your case management software and keeping track is really going to have you in a position on your opening statement to come in and have kind of a tour de force of professionalism. Do you have any more thoughts on that?
I do, but I don't want to jump in too quickly. Let me let you go forward. Yeah.
All right. I had the avoid bluster and maintain clarity. When I think about the times I have behaved badly, and there have been times, especially when I was a young lawyer, and now I'm embarrassed about ever having done that. It's usually when you are hurt or scared of something. That's when you do all the arm waving and histrionics. If you are there and you're ready and you have a ton of confidence in your case, you're not coming in there shouting at anybody. And I don't think that impresses anybody. I really think it backfires with the clients too. A lot of people thinking if they pound their fist on the table, the clients is like, wow, this is great. Because, I see a lot of advertising where attorneys, and I have advertised myself, but, where people, they have their fists up and they're rolling up their sleeves. And I don't think that really has the appeal at mediation. We're not in a cage fight, for crying out loud. So try to avoid that if you can. But moving forward, and I think this is probably the most important point of this slide, is in a mediation opening, present your strong points very strongly with as much detail as you can, both plain up, without going on and on for 6 hours, but hit them with your best shot, kind of. But the defense too, on the defense side, if there are some really strong points about misrepresentations, prior accidents, prior injuries, how prior injuries are similar to what the clients had now, those are the things that you present. And on the plaintiff side, how look at what happened. There's big impact. Look at the pictures of the car. The client has the client has XYZ and medicals, and here's their injuries, and here's how it's affected them. Keep those points as brief as possible, but some of them do need some texture. So don't be afraid to put that out there. But what I would advise you not to do, and my place isn't to advise, but for mediation, if you want success at mediation or even at trial, is don't load down anybody with a bunch of minutia. If your client had their knee fractured and they had a spinal surgery, those are the things that you bring up. What you don't want to say is like, yeah, they had a spinal surgery and their knee was fractured and they had a knee replacement and they had a bruise on their left toenail and one of their fingernails, the nail was discolored, and they had a little bruise, they had some itching on their elbow. You don't do that. And the reason is this, because that dilutes your argument. What sometimes attorneys think they're doing is they think they're taking the big points and pyramiding on top of that the small points, and it's really going to impress everybody. And what it does, and there's a lot of studies on this, I won't mention them now, but this area has been studied. And what you do when you make an argument like that is you dilute your argument, because people don't stack the bad arguments on top of the good ones. They average. You have 3 super strong points, and then you bring up all this other stuff that is minutia and fluff. You've just devalued your big points by half. And And just, one kind of anecdotal thing about this, I notice on a lot of these, just to show how this is used to effect, on those pharmaceutical ads where people are dancing through fields of flowers and it's sunshine and everything's
Yeah.
beautiful because they've taken some kind of pharmaceutical. What they always say is at the end, you know how they rush and say, well, it could cause this, this, and this. What they always do is they'll say, could cause blindness, stroke, heart attack. And then they'll say, oh, and and it may cause an unpleasant feeling in your little finger, or it may cause, a slight itching of your palm. And, sometimes, and the reason they do that is because it dilutes the horrible
The
thing.
first four.
If they just came
Death.
up and said, heart attack, stroke, blindness, you're going, oh my God, I'm never going to take that stuff. And
Exactly.
when they dilute it, people are like, oh, yeah, itching,
Not bad.
it's not too bad. So that's my advice on that. And I know you have something to add, April.
Yeah. Okay. So I had a couple of thoughts on this. First, I think generally lawyers come into opening remarks and do a good job, at least in my experience. To underscore avoiding minutia, I think sometimes if you've not taken the time to prepare the mediator, you may wind up talking more than you really need or want to. And so don't miss the step of just taking the time to maybe give your mediator some information in advance so you're not using the opening remarks and getting bogged down in a minutia. You can focus on the strong points. And then I think it's important to be very clear on the damages you're seeking, or the damages that are going to be discussed in your numbers. I think that, and I don't know if you've seen this done, Greg, but I think that you establish credibility also if you can acknowledge and address acknowledge the reform laws if they apply. I mean, you can. I know that there are times where lawyers don't necessarily want to give an exact breakdown of a global number. It's great when you've done that, but if you don't, you can let the other side know you're fully aware of and you're accounting for the reform law. And then finally, I would say, what was my note here? Probably to make sure that you let your mediator know, in advance so you don't lose time. That was the last one. I already covered that.
Sure.
Did we have anything else on this slide? Because I think where we're heading next is some smaller points before we close. And I think here is where we were going to talk about, at this point, once you get through the opening remarks and you're heading into caucus, if you've done everything before this step, you're now positioned for negotiation and you're well positioned, Greg. Is that true?
I think so. I think really if you have this foundation and you use it in every case, you don't have a scattered approach when it comes time. So it's just the old, you put the work in on the front end rather than the back end. And
sure,
once you hit opening statement, you should be in a position, here's the thing, if you're prepared or if you're not. And as I think it was Vince Lombardi said, it's not the will to win that matters. Everybody has that. It's the will to prepare to win. And that's what you need.
Yeah.
Will to prepare to put your case together and put the time in. So
I remember the thought that escaped me just a minute ago. When we think about some of the opening presentations that are lengthy, I think there are times where lawyers will use it as a time to present everything that they would intend to show at trial. And I have been finding over the years lawyers pulling back from that. So yeah, I think that you've hit it straight on here with highlighting the strong points and really focusing in what's going to get this case settled or not. Okay, do you ready to move forward?
Yeah.
Pending motions, your favorite. So a word on pending motions.
Yeah.
So we've mediated cases where, people come to mediation, there's a motion pending. Okay, but you're in mediation and the mediation is it's not a situation where something has been filed and prior to a dispositive motion hearing, everybody's decided, let's go to a mediation, right? So let's talk about what you mean here when you say avoiding gamesmanship.
When I see a case that's been in litigation for 2.5 years and there's a summary judgment filed before right before mediation, or a motion to dismiss for fraud, or any kind of motion that could be dispositive that that the attorney's heart doesn't really seem to be in. I think it kind of is confusing for the clients. And what I would say is file all the motions you want. I get that. I'm not here to tell anybody how to litigate, but what I would advise doing for success at mediation is not making a big deal about some motion that has a 2% chance of getting you what you want, because it can really kind of infect the whole mediation. I mean, really, in a mediation, you should be prepared to come there and settle. There are cases where emotion is so important that it can be case dispositive, but that's 1 in 1,000, and maybe not even that. So I'm not a big believer in finding these motions and coming in and making a big deal about them, unless they really are a big deal. And in most cases, from what I see, they never have any real effect. But I have seen a few cases where people said, we're not going to settle, we're going to have this motion heard, then the motion doesn't come out their way, and guess what? The other side feels super empowered. The case goes to trial, and it just doesn't work out. So be careful relying on getting a low percentage motion to try to carry the day at mediation, because generally nobody's scared.
And I would say, and as we talked this through, what you don't want to do is shoot yourself in the foot, because you're talking about, you're overselling a pending motion, and your client at some point disengages from the settlement discussion by saying, what, I think I'm better off let's just wait on that motion, because you've talked it up so much that now your client feels like, maybe why are we even going to settle today?
Right.
It doesn't happen a whole lot, but like we said, if a pending motion is a really an issue, if everybody's there because of a pending motion, we all know it. The mediator has been alerted. We've got the motion, we've reviewed it, you've given us law, and that was the whole thing we talked about in the opening session. Other than that, chances are each firm can say, you know what, we've got some wins on this motion. And so as the mediator in both rooms, we're hearing that. Let's focus on the settlement discussion, and let's not put the client in a position of being confused as to whether or not they should even be having this settlement discussion.
Right.
Okay.
All right. I think we've covered that one.
Next slide. Optics. This one was really important to you, Greg, in terms of
it was
on Zoom.
Because and then the reason is because I read a lot of like behavioral psychology and behavioral economics and stuff like that, and like Daniel Kahneman's Thinking Fast and Slow, and I realize that the optics of things have enormous effects, and people kind of they want to kind of poo-poo it sometimes, but I'm telling you, these things matter, or at least they from what I see and from what a lot of other people say who have studied it, they matter a lot. So do you mind if I go on about this one?
No, go ahead. Go ahead.
What I would say is I'm going to go kind of out of order here, but as far as the optics go and the effective mediation, I think it's always good to have the client there with you on a Zoom mediation, in your office with you, if you can. I'm a big believer in Zoom. It saved everybody, a lot of time, money. 6 years ago, nobody ever thought they'd be doing this, or nobody wanted to do it. And now, nobody would ever give it up. So the Zoom ship has sailed. I can say that. So, and to great effect and to great benefit, really. But I would caution everybody about being too comfortable with it to the point where both attorneys and clients don't seem engaged. As an attorney, when you come to mediation, and I don't see this very often as a mediator, thankfully, but you want that mediation to be the biggest thing of your day, because it's the biggest thing in that client's day. And I think the client also needs to be very engaged. But when I get the feeling that this is just another thing on the schedule, and the client isn't really in for it, nobody is there, so to speak, the case it's tough. It's tough, but very few attorneys come to mediation with that. But I would just say, even if you were look disengaged, it doesn't help. So just with the clients, if they are going to be by Zoom, obviously, and they are somewhere else, they can't be in the office, have someone on your staff do a real quick run through. Wouldn't you agree, April?
Yeah, it's good if you can go through mediation mechanics. And I mean, and frankly, in the course of the representation, schedule a meeting or two on Zoom. I mean, do it that way. And then by the time you get to mediation, they're familiar with it.
Right, exactly. And then, obviously, I think you may have mentioned confidentiality. I mean, make sure the client knows they can't have a whole bunch of people back there in the background listening in on mediation, which obviously is confidential. If they are in a position where they have to do a mediation somewhere out of your office, I would encourage you, and maybe not everybody feels as strongly. I don't think it comes off well to the insurance adjusters a lot of times when a plaintiff is sitting out in their car for mediation. I mean, other people may disagree with that, given our, the way we all are and how little time we have these days. But, it may be the only private place they can be. But if they're going to be somewhere for mediation out of your office, try to make it inside of a building. And if not, if they have to do it in their car, make sure that they, have a clean shirt on. They're not wearing the shirt they were, pouring concrete in 5 minutes ago or something. Because, what's like if they're at home, what's in the background makes a big difference. And, I have seen several clients at home, and the clutter is something like you'd seen on My Hoarding Life or something. So you really don't, you want to get them to just clean the setup a little bit, have a decent shirt on. My theory always is, if you wouldn't wear it to an in-person mediation, don't wear it to a Zoom mediation. So I
Good
know you
rule.
probably have something to add.
Good rule. Well, there are best practices by the court on how to, on Zoom mediations, but
Sure.
absolutely. I always say, never get so comfortable that either the client or the lawyer forgets. You can make a good impression on the other client in the room. So that's what I would say on that. And then I know that if your client is at home and not with you in the office, you do, I think, have the increased risk of other people being a part of that process, maybe even unbeknownst to you. More recently, I was in a situation where I do believe the plaintiff in the case was alone, but as the mediation progressed, people started coming home, and then family members can hear and begin chiming in on, well, wait a second, I thought you were going to hold out for X number of dollars. So, Greg, we have a couple of questions, and I think we're down to like 3 minutes. You want to do like a quick? You want to do the questions or key takeaways?
Let's do the questions. If that's
okay, because the key takeaways are there for you. We've gone through the approach. Greg, what's the best advice for tempering a client's expectation at mediation?
The best way to do that is in the pre-mediation meeting.
Start early, don't wait.
Right. Yeah. Start early and start often.
Yeah.
That is the time you do that. If you're butting heads with your client during a mediation, that's tough. So, that space between the mediation, pre-mediation meeting and the mediation, that's where things can kind of soften and you can come together with the client. But, like I said, you never want to intimidate. You just take a rational approach and tell them, because look, if you have a case where there's a very low impact case, there's, a scratch on the bumper of a car, there's, $10,000 in medical bills, and the client thinks the case is worth $1 million. They're probably going to be dissatisfied. But what your job is to educate them that, that really does not comport with reality, regardless of all the anecdotes that you may be hearing from Aunt Edna or whatever, somebody who knows somebody. So, the expectations have to be tempered by a presentation to the client of really how you value the case, why you value it that way, and what, and that's an art, really, and it takes some time to develop that. But the trouble always comes when the client's expectations are clearly out of sync with what 90% of people or 95% of people you ask on the street would say the case is worth. So, if everybody kind of looks like they've smelled something bad, you might want to have a talk with the client, because sometimes people think they have enormous jury appeal and they're going to carry the day, and it doesn't work that way.
Well, we are at 1 o'clock. We did have some other questions that we received. We can actually answer those by email, Greg, instead of addressing them today. I think you've done a great job letting our audience know about this approach. And Kathy, we'll turn it over to you. Thank you all for being here today.
Thank you, everybody.
If you're a Florida attorney, please jot down the Florida Bar course number so that you can post your CLE credit online. It is 2411393, N as in Nancy. That's 2411393, N as in Nancy. We're building our webinar schedule for the coming months, so please watch your email inbox for news about our future programs. On this slide, you'll see contact information for our presenters and technical assistance. Thanks, Greg and April.
Thank you so much.
Thank you, everyone. Have a good day.
Thanks, everybody.